Good afternoon, everyone. My name is Karyn Booth, and I'm a partner and leader of Thompson Hine's transportation practice. I would like to welcome you to today's webinar, and I'm delighted to introduce you to our panelists today. I'm joined by my Thompson Hine colleagues, Dan Utso, Senior Counsel in our International Trade Practice, and Jason Tutrone, Senior Managing Associate, also in the Transportation Practice. Before we begin, I wanted to review just a few housekeeping items about the webinar. Today's program is being recorded, and we will send a link to all attendees within 48 hours of the presentation. We also will be offering CLE for today's webinar, so please be sure to fill out and return the webinar affirmation form that can be found in the handouts section of the control panel located on the right-hand side of your screen. The form provides instructions as to where to send the completed form, and I will announce the tracking code at the end of the program. Also, in the handout panel, you can download a copy of the PowerPoint slides, as well as the bios of today's speakers. And I want to let everybody know we welcome your questions today throughout the webinar. Please use the question panel option also on the right side of your screen. And our plan is to address your questions at the end of the presentation. Again, thank you for your interest, and we're going to get started since we have a lot of content for you today. And I wanted to just start by going over quickly the agenda for the webinar. Obviously we are you all are experiencing unprecedented port congestion and supply chain disruption. And so we want to talk to you today about a number of supply chain strategies to help you address transportation related challenges, as well as commercial contract issues. So I'm going to kick things off here today and really focus on kind of where we are with some of the problems we're hearing about in our practice, and then address what are really some of the government policies and remedies that are being looked at to help companies deal with these supply chain problems. I then am going to turn it to Jason, who's going to talk about leveraging contract issues with transportation providers. And then Dan is going to address a number of commercial relationship issues between buyers and sellers, but also what's coming down the road in the Biden administration with respect to supply chain issues in both trade and transportation. So with that, I really would like to just kind of dive right in here and talk about a number of the issues that I'm sure many of you are experiencing, and that, as I mentioned, that we're hearing about in our transportation practice. The problems really are unprecedented, I would say, in scope, but I think even more so in duration. The weakness of the cargo delivery network, I would say, before 2020 and 2021 was apparent, but it really wasn't until the pandemic that we really saw things hit a breaking point. And so this, issue of port congestion is truly systemic and sustained. The number of ships that continue to be at anchor in the West Coast and in other locations around our nation is really been a huge issue. And we've noticed that it's been a challenge to try to clear that backlog, and we're going to talk a little bit more about that. We're in a situation where the demand for freight and for capacity on vessels exceeds the supply. Obviously creates huge challenges in trying to get timely bookings on vessels to get your goods on the ships and help you with your planning and obviously your supply chain relative to delivering to your customers and getting products on store shelves. There's equipment imbalances relative primarily, I would say, to chassis at the ports needed to move containers, and of course containers themselves. There's an imbalance where we do see exporters in particular having really difficult challenges trying to get access to an adequate number of boxes. You have steamship lines that have interests commercially and due to demand in Asia to get empties back to Asia as fast as possible. So this is also creating a lot of snags in the network. But what this is leading to is just really astronomical increases in costs that shippers, importers, and exporters are facing, particularly in the area of demurrage and detention charges. So we're going to talk a little bit about that. You might have contracts with your steamship lines or NVOs that are not being honored. And so we're going to try to address some of those issues. And then, of course, just skyrocketing freight rates in addition to demurrage and detention. When you're not able to perhaps use your contract, or you can't even get a contract, you're forced to ship in the spot market. And those prices are as high as they've ever been. And then, of course, just business interruption in general. How do you manage that? So how did we get here? I did want to just really quickly touch on a few market considerations. You know, we did see COVID have a major impact here, where freight demand dropped precipitously with lockdowns that happened both overseas and in our country. And this has led, of course, to worker shortages that, again, have been exacerbated for a variety of reasons. Of course, truck driver shortages existed before the pandemic. They have only worsened. But then we had, of course, a number of folks being afraid to come back to work, perhaps incentivized not to come back to work. And now we're even seeing vaccine mandates have issues on the supply of workers, which clearly is having an impact here. And this has led to exporters and importers paying the highest transportation prices and surcharges than they ever have before, in exchange for really what is the poorest level of service. And that's a really big problem. And typically what we see is that when problems arise, you know, you can turn to the commercial market, you can work with your suppliers to help address these issues, and that's just not been happening here. Frankly, there's been a breakdown, and therefore that has led to a number of actions by various government agencies, a number of complaints and requests for government to get more engaged. So I want to just start quickly with some of the actions that the U.S. Federal Maritime Commission has been addressing. And the FMC, for those of you who may not be familiar, is really a small independent agency that has jurisdiction over international ocean shipping. Its mission is to help fulfill a competitive, and I think the key word here, reliable international ocean transportation system. And this agency is responsible to administer and enforce a federal law known as the Shipping Act of 1984 and amendments to that law that occurred in '98. And essentially what this law does, what this agency does, is it regulates the practices of the ocean carriers, of NVOCCs and freight forwarders, and of marine terminal operators. And so just highlighting a few things that the FMC has been involved in that really touch on a number of the issues and challenges. The first is an interpretive rule that was issued in May of 2020, kind of right really in the middle of when the pandemic had gotten underway here, on demurrage and detention practices. Demurrage, of course, are charges that get imposed on loaded containers that sit at the ports once they've been offloaded, if they're not removed within a free time period. And detention applies to returning empty containers back to the providers at the ports, also within an allotted free time. And those charges have just been extraordinary during this pandemic. And the FMC has issued an interpretive rule regarding reasonableness that have to be sort of considered if you were to try to challenge these charges as being unreasonable under the law. And I'm going to dive a little bit deeper into this in a minute, but the focus and the reason that this rule got really issued in the first place, and Thompson Hine was very involved in that effort in representing a coalition of trade associations, was that really even before the pandemic, there was a huge increase in these charges when congestion or other factors were occurring that were beyond the control of the party that's getting assessed the charges. The FMC also started an investigation, fact-finding investigation number 29, And this investigation also got started really during the pandemic. It was intended to focus initially on commercial solutions that could be brought to bear by bringing stakeholders together to address a lot of the supply chain problems that started, again, really around that kind of summer period, summer of 2020. But it quickly morphed into something more than that. And the FMC started investigating whether or not the ocean carriers and the terminals were actually complying with this interpretive rule on demurrage and detention, whether their practices were in fact reasonable. That investigation is ongoing. There have been some interim measures and recommendations that have come out on that, recommending some changes both to legislation, but also really this next bullet here on things the FMC can do to help importers and exporters validate the accuracy of demurrage charges. So look for a future rulemaking that should be coming down the pike really very soon on demurrage billing practices. You know, are the bills that you get containing these charges, do they contain enough information to help you validate those charges? So that's coming down the pike. But also some additional information and policies are going to be issued around their complaint procedures so that companies understand how you can access the FMC if you're having problems that you want to challenge, but also around the issue of retaliation. There's been a lot of complaints informally to the FMC, but not a lot of formal complaints. And what we're hearing and what the agency is hearing is that there's a lot of concern around fear of retaliation. If I bring an action against my carrier for unfair demurrage practices, are they going to penalize me and not get my cargo on the ship? We haven't really seen that happening, but it's a, you know, certainly a valid concern folks have, and the FMC plans to address it soon. They also have engaged in audits around demurrage and detention, having recently issued some best practices. I can't say I saw a whole lot of meaningful change here, really more asking the carriers to be more clear. And they also have a new shipper advisory committee that just got in place. You can find information about that on the website. Contact some of those folks to be a representative as they engage directly with the agency on how to have greater clarity and transparency around data for ocean shipments, and also to deal with some of these unfair business practices. So just diving a little deeper on the FMC's demurrage rule, because we get a lot of questions about this, and there really is a lot of helpful information in it for importers and exporters. But first, just to give you a little bit of background, as I said earlier, the Shipping Act requires ocean carriers and NVOs and terminals to have reasonable cargo handling practices. And that's been interpreted for decades to include demurrage and detention. So this is a federal law that requires reasonableness. Well, reasonableness is a very broad standard. It's a very fact-specific standard. There's not a bright line test that really can be followed here. It requires a factual analysis for every charge against every container. And that does make it a little bit challenging from a resource perspective. But the purpose of this rule is to promote network fluidity by ensuring commercial practices that are reasonable. And the purpose here is that if a charge you're getting assessed is not going to promote efficiency in the network by getting cargo picked up in a timely fashion, let's say because the port is congested, because there's not a chassis available, because you can't get an appointment or your trucker can't get an appointment for pickup, well, that is not meeting the efficiency principles behind demurrage and detention charges, and those charges are not reasonable or lawful under this interpretive rule. So that is this incentive principle outlined here. That is the basis of this rule, and that is how importers and exporters and draymen should be evaluating whether or not the charges they're receiving are in fact reasonable and therefore lawful. Now, this rule is industry guidance. It's intended to be applied case by case because every situation is different. You know, one importer may have a problem with a chassis, another may have a problem with an appointment, and therefore you need to kind of evaluate, as I said, each shipment on a shipment by shipment basis. But another key principle that is involved here is cargo availability. In order for charges to be considered reasonable, they really can't be assessed until you have notice and access, physical access to the cargo. Historically, carriers would offload containers and they may start that free time clock ticking, which, you know, is the period you have to pick up cargo before charges apply, immediately before the cargo is actually physically available. And the FMC clarified that that's not proper. You should have notice that you can actually get into the port, get access to the container, and of course, availability would also mean there needs to be available appointments, there needs to be a chassis available, etc. And so a lot of key issues included in here. And of course, with the major port congestion that's happening, there's a number of instances where clearly people are paying for demurrage and detention when their cargo may not in fact be available, or it's not their fault for the reason of the delays. This rule also requires reasonable billing and dispute resolution practices. I kind of touched on that about that rulemaking that's coming down the pike. The rule also recognizes that everybody in the supply chain has responsibility with respect to the reasonableness, and so cargo interests have to do their part. They need to fulfill the retrieval responsibilities. They got to, you know, hire their trucker timely. They have to ensure the appointments are being made timely within the free time period. And they do need to submit proper paperwork and, if necessary, pay for freight in advance if that is in fact required. So how do you use this rule to your benefit? You know, I encourage you to get familiar with the key principles that I've outlined. There are many more. It's a pretty detailed rule. Know your contractual relationships and how they may affect that incentive and efficiency principle I touched on, as well as the cargo availability principle. For example, you know, if your shipments are coming in as an import, you know, who's responsible to arrange the truck movement? Is it carrier haulage where the ocean carrier is responsible, or is it merchant haulage? There are things you can do to help manage those relationships to mitigate these charges. Are you contracting direct with a VOCC or an NVOCC? And Jason's going to touch on some of the contract provisions and terms that you can think about to help mitigate demurrage costs. But again, those contract relationships make a difference. You may need the help of your forwarders and of your NVOs if you're not contracting direct with the steamship line to get you the data you need to evaluate the validity of these charges. Who's paying for the charges? Who's receiving the invoices? Is somebody paying on your behalf? You need to look at not just your contract terms, but your processes that you may have internally to manage some of this risk and validate these charges. You need documentary evidence if you want to perhaps challenge these charges. Were gates open? If not, is your trucker, can they give you a screenshot? Can they collect information on your behalf? If they tried to get an appointment and it wasn't available, again, can they share that information with you so that you can dispute that there was no efficiency here, we couldn't get access to the cargo even though you told us it was available? And what are your options for actually disputing these types of charges? There are tariff processes. You need to be informed about those. Make sure they're reasonable. If they're telling you you have to dispute a charge within 3 days of payment, that may not be reasonable. You can file a complaint at the FMC if you want to try to get money back because you believe the charges are not reasonable. Those are formal complaints that have to be litigated. There's a whole process that goes with that. But the FMC also has an informal dispute resolution office where you don't need attorneys. You can access them for free. You can bring an informal complaint and they will help you mitigate that and walk through that and contact the provider to try to settle disputes. The downside to that is it's a voluntary process. They can't order the agencies or the providers to actually issue money back. And your contracts may have other provisions around dispute resolution. I want to turn quickly now to the STB, who has jurisdiction over rail transportation. Obviously, rail transportation also is a critical connectivity to the supply chain for international ocean movements. It's also critical on bulk rail movements. And this agency has also been taking steps to try to deal with some of these challenges, again, primarily focused in the area of demurrage practices. There are some differences that come into play depending on whether it's bulk rail or intermodal movements. But the STB has been very good about monitoring demurrage revenue. You can get all this information on the website. You can see the increase, frankly, in revenue that the railroads are getting. The chairman has been very focused on congestion at certain connectivity points, Memphis in particular, and expressing concerns about increasing storage charges on intermodal containers, as well as just rail service in general. I think, Chairman Oberman has really been out in front to try to shine a light on these problems as soon as they arise, writing letters to the railroads. He also is being a little bit careful. Government has to be careful not to have too heavy of a hand where they may be concerned about making supply chain matters worse. So just quickly around STB demurrage, because again, that seems to be the primary focus of the agency and complaints, where intermodal containers are stacking up in rail yards, or perhaps it's a bulk rail movement and your private cars are sitting on track, or there's problems with missed switches. The STB has its own demurrage policies. It also is non-binding, it's guidance, but it has very helpful information in it. And this agency has also issued demurrage billing rules, which just took effect this October, that requires the railroads now to provide far more detailed information with their demurrage bills. They have to give a number of different data points to help you validate the charges. They need to give you machine readable backup that's something that you can use to compare to your own information to help validate the charges. But I wanted to touch on a key issue around demurrage on intermodal containers, and that is that intermodal movements are exempt from STB regulation. And this means that you cannot access the regulators or get a decision out of the regulators unless you first revoke the exemption if you wanted to challenge storage charges on intermodal containers. There are processes and procedures for doing that, and it's not insurmountable by any stretch, but it is an important data point for you to understand that there's a little bit of an extra obstacle or hurdle to accessing the STB if you believe that the charges you're experiencing at rail yards are unreasonable. So just some practical considerations around demurrage. Again, to get money back, you need to file a complaint. The burden is on the party complaining to prove their case. You need facts to support that complaint. And that's what I talked about earlier, about trying to build that in advance. Concerns about retaliation I touched on, but also, again, the STB, like the FMC, also has an informal dispute resolution arm that you can use free of charge. And sometimes there's been a lot of success here getting some settlements. So let me turn very quickly to Biden administration. This has been all in the news. Freight transportation in the mainstream media, as we all have seen, has really tried to get more engaged through a collaborative effort, bringing all the supply chain actors together. Kind of the key step here, we've all heard about getting the West Coast ports to operate 24/7 to try to help clear the backlog. Frankly, we're seeing it in the news. Great idea, but some key challenges that's gonna, that have impeded essentially the ability of this to just work very quickly. And this gets back to driver shortages and other worker shortages. Because of that, this disruption is predicted to continue well into 2022. That's not good news. Hopefully things will get better sooner than that. but right now that is what is being predicted. DOT is collecting comments and information from industry. This happened just recently, trying to get as many industry solutions that they can find to help with the backlog and the congestion and the bottlenecks longer term. So I did want to bring to your attention really a key issue that's fairly new here. Just last Friday, the ports of LA and Long Beach adopted a new container fee to help deal with the backlog of the containers. These are unloaded containers only. Empties are also a problem, but this new fee would apply only on loaded containers. And it's a container excess dwell fee, and it would be assessed by the ports against the ocean carriers. It's $100 per container that increases every day if that container is not moved within a specific period of time shown here in the purple box. 9 days for truck moves, 6 days for rail moves, and this fee is in effect for 90 days. Now, there are some concerns about this from the importer community, since it is to apply on loaded inbound boxes, and that is that this fee seems to serve the very same purpose as demurrage, and the ocean carriers are providing notice to their customers that they simply are intending to pass this fee through to the importer. And so here the questions are legally, is that lawful? If you are already paying demurrage and this new container dwell fee serves the exact same purpose, is that a double dip? And there are some real questions here, some ways to try to avoid it. Look at your contracts. There needs to be notice of tariff price increases, and does it violate the FMC's interpretive rule that I talked about earlier? The last thing I want to touch on is some action that Congress is taking. I'm going to be really quick here. Congress also is getting in the game, separate and apart from physical infrastructure. They have introduced a bill in the House, OSRA 2021. It's a bipartisan bill. That's a good thing, that would seek to address really service problems and unfair business practices. Here is a list. I'm not going to walk through all this. You'll have the slides of the issues it's touching on. Demurrage detention, big part of this bill, wants to get expedited proceedings, touches on service contracts, and prohibited acts, really around the inability to get timely vessel space or the interchange of equipment. Lots of good stuff in here. But this is in the works. It's got broad support from industry, opposition, not surprisingly, from ocean carriers and terminal operators who do not want increased regulation. Next step is to try to get a Senate companion bill. I'm hearing that is going to happen. And so just really wanted you to be aware of this. More information can be provided by us or perhaps through your trade association. So let me now move on and turn this over to Jason, who's going to talk about leveraging contracts.
Thank you, Karyn. One of the most important things that you can do to address transportation issues is to have a contract. In fact, that's my sort of rule number one when trying to obtain logistics services. Always try to have a contract. There's some exceptions on the bulk rail side, but that's the general rule. And there's good reason for that. If you don't have a contract, it's going to be the carrier's bill of lading terms and its tariff terms and conditions that are going to apply. And as you can probably imagine, those weren't developed with your best interest in mind. Additionally, while Karyn was talking about government programs and regulatory requirements that might address some of these challenges, those programs, those requirements, those rules are really meant to provide broad, generic protections, and they might not be perfectly helpful to your situation. So that contract is really your opportunity to gain some tailored protection. And I would think of these government programs, government requirements, more of as a second line of defense. Now, while I certainly advocate for having contracts, I think it's important to level set expectations. In the current environment, you're not going to get everything that you want. It's a really difficult contracting environment. The carriers have a lot of leverage, but that does not mean that you shouldn't ask for things. You'll likely still get some protections in your agreements, and you'll cover items that are going to be important to you. Now, I was talking about how you want to avoid being subject completely to tariff terms. You're probably not going to avoid tariffs altogether. It's typical that you'll see contracts incorporate the carrier's tariff by reference, and there's good reason for that. Those tariffs contain uniform rules that help ensure efficiency of the carrier services by applying across the board to all shippers. These rules might touch on things such as how you book shipments and things along those lines. Nothing that's too concerning, I think, from a shipper's perspective. Additionally, the tariffs might contain accessorial charges. These are add-on charges for additional services that you might not have contemplated at the outset of your engagement with the carrier. Those things also aren't, I don't think, too concerning to have those incorporated by reference as well. But what you want to do, one of the purposes of the contract is to identify the issues that are important to you, to address and displace those tariff terms that you think are problematic, and then the remainder of the tariff might otherwise apply. So it's really important that at the outset, when you're engaging a carrier, you want to review the tariff, review the carrier's bill of lading terms, and identify anything that's problematic, anything that you think might come up and haunt you sometime in the future, because that's going to be your opportunity to address it through your contract. And then one other point on rail. Rail transportation, once you agree on a contract, that transportation is no longer regulated. And so if you incorporate a tariff, the regulatory protections that would otherwise apply to traffic that moves under tariffs doesn't necessarily apply to you. There's a little bit of a workaround here. You can, in your rail contract, specify that the tariffs that are being incorporated must be lawful. And that's one way to help try to get some of those regulatory protections to continue to cover you. Now, for more as to what you should put in your contracts to address these transportation issues, I think one of the top issues is capacity and getting some sort of capacity protection. And a common way to do this is through a volume commitment, where the carrier is committing to provide a certain level of capacity to you. Now, I will say that you should expect to provide a reciprocal commitment to the carrier, and we see that typically come up in all sorts of ocean contracts. Now, there are various ways to structure your volume commitment to ensure that it's going to work well for you and serve your purposes. You might specify the volume as far as a number of containers or rail cars. I would say that's the most common way we see it on the ocean side. Or you might say that you're going to commit, or the carrier is going to serve a certain percentage of your traffic between certain points. Or sometimes on rail, you might see the carrier is going to commit to serve a certain percentage of traffic originating at a certain location. Also, consider whether your commitment should be a universal commitment or a lane-specific commitment. Universal meaning that it covers all shipments, across all different lanes that you might give to a carrier, or where it's lane specific, that can provide you with a little bit more protection because you're going to be ensured that you're going to get the capacity that you need where you need it. Also, addressing your volume commitments, your service commitments, any sort of adjustments that might need to be made. There may be a force majeure event. How does that impact your volume commitment? There may be changes that the carrier is going to make to its service schedule. Again, how is that going to affect your volume commitment? Similarly, you want to address how a termination, because one party's in breach, impacts the volume or service commitments. And then I think it's really imperative that you clearly identify what constitutes a breach of the volume commitment and what the consequences are of that breach. I think right now what we're seeing is people have contracts, but they feel like they're not really enforceable. And that's in part because the volume commitment may not be clear insofar as what constitutes a breach of the commitment or what you're entitled to as far as damages. So here, I think it's really important that when you're identifying the breach, you identify, does the breach occur when you tender a shipment and the carrier says, no, I don't have the space for it, I'm going to reject it? Or does the breach occur, and this is what carriers will say, the breach occurs at the end of the contract if the carrier at that point hasn't handled all the shipments that shipments that you've tendered it up to your minimum quantity or minimum volume commitment. Similarly, as far as consequences, you're going to want to specify, are you entitled to, say, a specific dollar amount? And we see that that sort of liquidated damages clause comes up a lot in ocean contracts. But does that really cover you? Is it better that you get the difference between the spot rate and your contract rate? Because if the carrier is denying you capacity, what's ultimately going to happen is you're going to have to go out to the spot market and then book a shipment at what could be a sky-high spot rate. And so your damage is really that difference between the spot rate and the rate you have under the agreement. Another capacity protection that you might want to build in is a short shipping type of a clause. Here, what I mean by this is you want a clause that's going to address what happens when a party cancels a booking. And sometimes what you'll see is carriers will cancel bookings because they want to get freight that's going to travel in their spot rate, or shippers might cancel a booking because they make a lot of bookings hoping that they're going to get their containers on one vessel, and then once they find the right vessel for the right price, and they cancel all their other ones. So you want a clause that addresses this. Consider, what's the deadline for making a cancellation? How does that play in? Is there somewhat of an excuse that a party might have if they cancel before a certain date or time? Consider whether there should be an allowance. There may be a good reason why the carrier needs some flexibility to cancel certain bookings, and good reason why you might want some flexibility to cancel bookings, keeping in mind that it's likely that you're going to have a reciprocal commitment. Also, consider what your damages are going to be. It's likely that your damages are going to be similar to the damages that we were just talking about on the minimum volume commitment side, in part because if you have a cancellation of a booking, you're going to have to go to the spot market at that point. Another clause, again, related to these capacity issues, is a clause addressing rolled and split shipments. Here, what you want to do is consider how many shipments or how many rolls of a container a carrier should be entitled to before it's subject to damages. Similarly, consider also whether there should be a time limit on when a rolled shipment must ultimately travel. So, for example, if a carrier rolls a shipment on a vessel that was supposed to leave on the 1st of the month, does it have to rebook that shipment on another vessel by the 15th of the month or by the 30th of the month? So that's another way you can address these rolled or split shipments. Additionally, when you're talking about rolled and split shipments, we've got to think about what the damages are, what the damages you should be entitled to if the carrier does roll or split your shipments. Oftentimes, you'll see a specific dollar amount. I will say that nowadays it's hard to get a liquidated damages out of the carrier for a rolled or split shipment. You also might want to get expedited transportation costs, where you're going to have to expedite a substitute shipment to cover the fact that now the shipment that you thought was going to move isn't moving. Additionally, another type of remedy here might be a reduction of your volume commitment. So what you've guaranteed to provide to the carrier, and that gives you a little bit more flexibility there. Once again, here, as with all these other types of clauses, you're most likely to obtain an agreement, especially in this environment, if you're going to offer a reciprocal commitment. Now, earlier, Karyn was talking about demurrage, detention, and storage. You're going to want to address those issues as well in your contract. One critical point when it comes to these items is how much free time are you going to get? You need an amount of free time that's going to enable you to actually get your cargo either off of a port or out of a rail yard. So make sure that the free time that's in the tariff is what you need, and if it's not, make sure you put it in your contract. In fact, I would say just put the free time that you need in the contract, because the carrier can always adjust the tariff, and we see that. That does happen. It can happen, as short as 30 days notice, or even perhaps even less at times. Additionally, you want to be clear about how notice is going to be provided to you that your cargo is ready. Because if you don't get notice, or notice doesn't get to the right person, the cargo is going to be sitting at the port, and it's going to be incurred. It's going to burn through most of your free time period, or it might take you into beyond the free time period. You're going to be subject to demurrage or whatnot. So be clear as to who has to provide notice, when the notice must arrive, and then what happens once you get the notice. You shouldn't be encouraging. You shouldn't be incurring free time before you get the notice that your cargo is ready for pickup. Additionally, it's important to try to exclude any sort of charges arising from situations that are beyond your reasonable control. If a port is congested and you can't get in to receive your cargo, you really shouldn't be getting hit with demurrage charges. It does not serve one of those purposes that Karyn discussed of demurrage, which is to incentivize efficient use of a carrier's asset if you can't actually take the action you need to ensure that efficient use. So exclude those charges that you can't avoid for reasons beyond your control. And then a good practice is to incorporate that FMC and STB guidance that Karyn was talking about. Incorporate that by reference into your agreements. That way, there's really no question as to whether the principles that are announced in that guidance will apply to you. And then another issue that does come up, especially in the current times where we have a lot of delays to shipments, is how do we incentivize the sort of reasonable transit times and carriers sort of sticking to our expectations around when shipments are going to arrive. There's a few ways in which I've seen this done. One is you can have a bonus malus type of clause tied to transit time performance. Usually there, I think you're going to find the most success if you are providing a bonus rather than essentially a penalty or a damage amount when it comes to transit time performance. Additionally, you might want to adjust the volume commitments based on transit time performance. That could, that definitely would incentivize the carrier if suddenly now it's seeing that your commitment to the carriers is now sort of getting chipped away just because the carrier isn't delivering on time. And then also consider perhaps having a liquidated damages clause that's going to specify a dollar amount if the carrier does not deliver a specific shipment on time or doesn't meet some sort of transit time metric. We also see clauses that specifically spell out a calculation of damages that includes the additional cost that you're going to pay to expedite a substitute shipment, where, for instance, a delay requires that you provide another shipment to make up for the fact that the one that you've got on the water or wherever it might be is delayed. Other things to consider when you're carving out some sort of delay provision: how are you going to measure that delay? Is it a delay across all traffic that you're giving to the carrier, or is it a delay? Are you measuring delay related to specific lanes? Sometimes going that lane-specific route might be a little bit better, in part because you now sort of have established a baseline or a target for where you need it on a lane where perhaps you might have more constraints than another lane. Also consider the measurement period as well. You probably don't want a very long measurement period, and were you on time all of last year? That's probably not going to work. some of those periods where the carrier was performing well might dilute or drown out those periods where the carrier wasn't performing quite as well. So those are some of the types of clauses that you might want to include in your contracts. I'm now going to turn it over to Dan.
Great, thanks, Jason, and thank you, Karyn. And mindful that we're coming up on the kind of the final stretch or the home stretch. I did want to just build off of some of Jason's comments and then Karyn's earlier comments on what are some things that we're seeing on the ground on the transportation side, but also as they intersect with other areas. And those of you that know me know I always have some kind of corny saying. And we talk so much about supply chain, but we're really dealing with is kind of the supply verse, and that's because I have a 10-year-old. We watch a lot of Marvel, MCU, the Avengers, for those of you, Loki, WandaVision, for those of you that are into that. For those of you who don't know, it's all about the superheroes doing time travel and quantum physics and parallel universes. It's very difficult to be a parent these days and try to explain this stuff. It's not Superman flying around the earth and making it spin backwards to go back in time. So a lot of time on YouTube reading what comic book nerds are talking about these days. But more to the point, the supply verse is actually the complexity. You can see all the layers. I think we actually have one question in the hopper right now asking this exact question of all of the multiple actors in this space, the regulatory environment, et cetera. And that's what we're dealing with. There is not a silver bullet to this solution to where we're going on supply chains. So I did want to just take a zoom out because I appreciate, or I think we appreciate in terms of understanding that virtually every company we work with right now, usually transportation was off to the side. Nobody cared until there was a mistake. Maybe you could have some advantages of getting some cost reductions and get a nice pat on the back. But on the whole now, this is front and center for the C-suite. Everybody's looking at transportation. It's in a microscope, under the microscope, because it's increasing costs throughout the company's operations. But what are some of the things Jason mentioned right now in terms of the contracts that he and I and Karyn and so many others on our team are doing? On the shipper side, on the company side, there's just not a heck of a lot of leverage right now in negotiating these contracts. But I cannot re-emphasize something Jason said more is have the contract. Have your own contract tailored to your circumstances. But what we're seeing is because the transportation contracts are often negotiated on their own, kind of that's what they do over there in the transportation distribution logistics team. It's often not connected with what's going on in sales or our other supplier agreements, et cetera. And this is particularly for the in-house counsel that we work regularly with, and many of you are on the line, that's on one side of the house and transportation's over here. But for one of the major questions that's popping up right now as we're going through this is, as we're negotiating with our customers and on the other side dealing with our carriers, can we still offer the same services that we had to our customers? So if I'm looking at my distribution centers or distributors and my retailers, et cetera, can not only I make sure that our product gets there and on the shelves, but also I may have arranged for reverse logistics, things like returns, recyclables, et cetera, where right now carriers don't want to pick up those lanes. So you may be dealing with the same carrier, have the same agreement, but the carrier is saying, no, I don't want to take those more low value, low priced lanes. I'm going to, in this time of high demand, go for the more expensive routes. Well, then that begs the question, can you continue to service your customer in the way that you always have? Do you need to renegotiate those agreements and all of those relationships on the supply side? And I think so often we kind of get locked in on one set of contracts that we're not thinking about that supply chain or supply verse. Similarly, when Jason was talking a bit about risk, and we have in so many of our contracts various clauses for delay, et cetera. The thing is right now, if you have delay in your contract, it's going to get struck out on the red line. And so the trade-off always is, okay, we will have delay damages in there, but we'll cap those in some way. But when the risk team traditionally at your company has been looking at risk in your transportation contract, it's typically looking at the value of the shipment. What if this rolls over in terms of actually rolling over, the truck rolling over, not roll over as Jason was talking about, the actual damage, we lose the container, et cetera. What is the value of our product on there? What is our insurance coverage? What is our claim? But now we also have to think about downstream as well. what other provisions, damage provisions, do we have in our agreements with if we're the supplier, that we may have with the ultimate destination? If we in our sales contracts, do we have any obligations? So when we're factoring in those caps, we need to factor in the complete picture. So often when we go in and work with a company or my clients in terms of let's do your transportation agreements, master transportation agreements, we're not just looking at the relationship with the carriers, we're looking at the relationship all the way down the chain until it ultimately gets to the shelf or ultimately to the customer. But those are factors in-house that often, particularly right now in the kind of extreme and the timing and tempo that we're in right now, that those will often get siloed. And it's very important to take, click on that zoom out on the Google map and make sure that we're looking at the entire risk profile of our transportation contract. And then we can use effective clauses. And in the same vein, as was said earlier, we may have caps in our agreements today that, quite frankly, when we renegotiate these agreements with carriers, are not going to be there next time around. So how does that also, in terms of the evaluation of the downstream risk? Now, mindful of the time, and again, if you have any more questions, please just go ahead and put them in the box. But here are some issues that get me back to at the ports of entry, not just behind or beyond the ports, but at the ports of entry. I'm a border guy, as many of you that I've worked with know, but there are some things that we're seeing because of this that are related to these issues, but are almost unintended consequences. Now, the big one we saw, of course, is the issues that are going on in Long Beach, LA, where all of a sudden somebody drops an anchor and potentially causes an environmental disaster. Now, that's still subject to investigation, and we'll let that be there. But one of the other issues is a lot of these goods are sitting around for a long time. The containers are sitting at the ports for a long time. They're sitting before delivery. They're sitting on the ships, on the vessels for a long time. They're sitting in neighborhoods. And I know I have our great friends from NASCO on here and others. We all know when we saw things at the US-Mexico border, Canada-US border, when we've had delays in the past, what happens when containers are lining and motor carriers are lining up in neighborhoods, right? These are not good situations, particularly if that's your freight. But one of the interesting things, I have not in my 20-some years of trade and transportation work ever seen a period like this with invasive species. When goods are arriving at ports of entry, guess what? They have pests, they have bugs, they have snails, they have moths, etc. And what's happening is you finally get your container to the port of entry. It's finally being offloaded, and US Customs or APHIS or somebody else says, that's not coming in here. And then you have to oftentimes take it out of the port of entry, ship it to a third country for fumigation, all of the transportation costs, which are already high, and additional delays. So one of the things that's very important is to make sure that if you have freight sitting somewhere, that it's protected, that you're working with your transportation service provider on tarping and other security, but also in your agreements, make sure that that risk is balanced. We typically use Incoterms, and Incoterms will often have who's responsible for customs clearance, but who has the risk of loss? Is it a customs issue, or is it another type of issue, a transportation risk issue, when you're talking about invasive species and the circumstances we're in now? So it's becoming a big issue. We're seeing a lot of this, a lot related. People are not cleaning out vessels the way they used to, so there is a lot of that going on. Grabbing pallets that may not be certified. So we're seeing all types of things. Not exactly something that's always top of the list within organizations, but it's something to think about. Just my freight is sitting somewhere for a long time. What's the risk? Species, those types of things, but also theft. And so who's also responsible for that? And I'm sure some of you have seen what we're seeing in neighborhoods in Los Angeles, Long Beach, et cetera, where the containers are getting stopped. And frankly, it's almost amazing how fast they can get in there, break into them, and unload them. It's like Jersey in some ways, but and I'll leave that joke there. Lastly, a couple other issues to think about. One thing, I do think if this continues to get worse, we're starting to hear rumblings that if these volumes continue to increase, that only CTPAT, trusted trader, or fast shipments are going to get approved and cleared. So that's something to keep an eye on. You may want to ensure that you're using carriers that are CTPAT approved. These are the trusted trader programs that came after 9/11. At some ways, we're going to have to manage this flow of freight, and that's typically the fallback position at USCBP. And forced labor, just as you're looking at your contracts, forced labor is one of the #1 priorities of the Biden administration in Canada, Mexico, et cetera. Make sure you take a look at those types of issues and have contractual clauses there, because that may add to delay. Finally, you know, the Biden administration, and I'm mindful of the time here, issued on almost day one an executive order looking at 4 supply chains: semiconductors, critical minerals, EVs and EV batteries, and advanced pharmaceutical ingredients, which are the vaccines, right? And looked at these. A report came out in June. I just want to emphasize that now a report is coming out in February of 2022 along these sectors. What the Biden administration is doing right now is looking at all of these sectors and identifying where are the areas that we're going to place a priority, where are the areas that we potentially may remove tariffs, impose tariffs, put Buy America or other type restrictions. This is the playbook for the Biden administration. So if you're wondering what's coming down the pike, not just in the transportation policy, but supply chain generally, or supply verse generally, keep an eye out for that report. We are engaged with the administration on identifying issues for these sectors. There's a lot of discussion going on. You can see a lot of that happening on the Hill, even with reconciliation. So it's just something that when you're looking ahead to your planning 2022, and as Karyn said at the outset, we don't see any breakup in what we're seeing right now in 2022. It's probably 2023 when you're starting to look at these issues. But where the Biden administration's going in key sectors is we're gonna see that in Q1 of 2022 next year. So with that, I'll stop there, just mindful of the time, and then open it up for any questions. So Karyn, I'll turn it back to you, and I see we have a few in the hopper already.
Great, thanks, Dan, and thanks, Jason, as well. Yeah, there are a couple questions here. If you want to ask a question, please use on the right-hand side the panel there. The first question, which any one of us I think can jump on this, question is, what does the small shipper, 500 to 2,000 containers per year, what can they do to try to control their costs? Many steamship lines, when a smaller size shipper, an importer, can't get basically a price to move the goods from the carriers themselves or capacity. So I guess I'll chime in on that, and then Dan and Jason, you may want to as well. It is, look, it's challenging for everybody right now. Large shippers also are not getting the space they need or the pricing they thought they had. But having said that, I think you always want to start on the commercial side of the equation and think about what alternatives might you have. You know, obviously changing your providers, turning to NVOCCs if you can. I think there are still challenges there. Working very closely with freight forwarders who may have other avenues to help you combine your freight with other folks who are having problems or who may have some tips to provide you. Think about, and I've actually been surprised that more of these haven't popped up, but the Shipping Act does allow shippers associations to be used. You know, shippers themselves can come together. There are a number of associations out there who essentially shippers can combine their volumes together and negotiate collectively. So you could think about whether you can join an existing association, think about forming an association. But outside the commercial side, and we didn't have time to get into it today, the Shipping Act does have certain prohibited acts that really haven't been triggered. There are a couple of complaints that more recently got filed, but there's an unreasonable refusal to deal or negotiate prohibition that does exist in the Shipping Act, which, you know, possibly could be implicated here. That is a very fact-specific scenario. We've done a number of kind of research into those issues, but you have to be willing to maybe call out some of the carriers on these issues. And if you can't do that, or you don't feel you have the leverage, think about turning to the FMC. They are there to help. Use the CATERS, that's the Consumer Affairs Office, there to help you navigate these issues. They will call the carriers up. They will help you where they can. So I think, you know, those are the things I can think of right now during this very challenging environment. I don't know, Jason or Dan, if you don't want to add anything to that. There's another question here. It's kind of a lengthy question. It basically, though, I think at the nub of this is getting at, you know, are there potential disruptors that can enter the ocean shipping market, major retailers like Amazon or Walmart. The question's kind of futuristic. Is it possible that somebody like that will come in and start becoming a carrier, managing their own chassis pools, running terminals to try to get more control, manage their costs better, over these problems. So again, I have a couple thoughts, but I'll turn it to Jason or Dan if you want to jump on that first.
I guess I'll just say that I think we see today that there are retailers and these really large companies who are going out and they're acquiring space as far as through chartering vessels. So in some ways, that's almost like a first step toward what might be envisioned here in the question. So I think that you might start seeing some of very large shippers, your Walmarts, your Amazons, start to really think about whether it makes sense for them to either obtain vessels, own their own vessels. Maybe they just have these vessel charters and they go out and they resell some space to make it even more economical. I think that's definitely a possibility. We already like I said, we're already starting to see steps in that direction.
Yeah, I don't have too much more to add to that. I think, Jason, you're exactly right. I think, that's already happening. Whenever you have a problem of this magnitude with this great of an impact on costs and on the supply chain, empty store shelves, lack of raw materials, it really leads to potential disruptors down the road. I think there's going to be a lot of thought around this. I wouldn't be surprised to see these types of questions and issues at trade association meetings in the future. To get that discussion going, but absolutely, especially the larger companies like those mentioned here are going to be looking at everything possible to try to manage this and protect their supply chain.
Yeah, and the question is to make sure we do it smart, right? I mean, I think the reality is whenever we have an incident like this, coming out of the pandemic, this is associated with that. When we came out of 9/11, what we saw, we have a moment in time to fix things, right? These issues are not new for the most part. Now the demand, the quantities that we're seeing at the ports, the volumes, et cetera, are on that level. But this is an opportunity from a regulatory perspective to maybe get this right. Now, what the private sector does and react, I mean, we are seeing a lot of chartering of vessels, particularly on the ag side right now to get things, where they need to be. But there's going to be a moment in time. The question is, there's a lot of things we're dealing with right now, not just in the transportation world. So is there going to be the bandwidth to get this done on the policy front? But it's going to be, I'm looking at that not just from a private sector solution, but are we going to be smart about this? And, I'm optimistic about that, actually. I think we learn, particularly on the US side, it takes us a while, but when we get the wake up call, we generally respond in a way that makes sense. So I'm optimistic, but I do think we're looking at least another year, maybe even 18 months, because even when it's fixed, it's not going to be fixed overnight. It's going to take a time to unwind in the system, and things are cyclical. So everybody's going to squeeze as much as they can out of this boom period if you're on one side of the equation, and then then things will kind of level out. But I'd strap in for the next year, 18 months here.
Great. Well, I do see that we're just a few minutes over the top of the hour. We want to be respectful of everybody's time. So just maybe wrapping up here, I do want to mention that if you are seeking CLE for today's program, the tracking code for that is capital T, capital H 1103. Again, the code capital T, capital H 1103. And if you're not currently receiving Thompson Hine updates and invitations, we invite you to go to our website. You can register to receive those mailings under the publications tab. And again, thank you all very much for your interest today and for attending the webinar. Enjoy the rest of your day and please stay well. Bye-bye now.